Hi. So today we will be having a conversation with Advocate Bijoy P Pulipra, where he will be discussing about the different aspects of corporate law. So, what are the laws that are covered under the corporate law?
So if you ask me that question, corporate law, I cannot confine the corporate law by putting a clear definition to what is included or what is excluded in it. Corporate law, in my opinion, are laws which are actually governing, regulating, managing or operating a corporate. Corporate, by the term corporate, I does not want to confine the term only to the companies. It can be partnership firms, or it can be limited liability partnership firms, it can be companies listed as well as unlisted companies, or even proprietorship concerns. So when it comes to operation or management or regulation of a corporate, there are multiple laws which are day to day affecting the operation or management of these corporates. If you analyze it, there are tax laws. When it comes to tax laws, it is Goods and Service Tax, Income Tax Act, or even customs, indirect taxes. When it comes to banking business, it's the banking laws, non-banking laws, competition laws, commercial laws, business laws. So all these laws, when it comes to insolvency related matters, SARFACI or IBC, Insolvency and Bankruptcy Code, all these laws can be collectively referred to as a corporate law. There is no specific the terminology called corporate laws. All these laws can be termed as a corporate law. I think I have answered that query.
So, what are the different forums one needs to approach in related to corporate matters?
I think your query is regarding in case of any disputes or in case of any clarifications where these corporates have to approach, which is forums like judicial forums or courts, right? So these corporate laws are basically specialized laws which needs specific attention or specialized skilled attention from the members who are handling it. So when it comes to tax laws, there are income tax officers or income tax appellate tribunal. Then above that, court procedures. Then comes to Companies Act, there is National Company Law Tribunal, Appellate Forum, National Company Law Appellate Tribunal. Above that, Supreme Court of India. When it comes to SARFACI matters, it is DRT, DRAT, then Supreme Court of India. When it comes to IBC, it's again NCLT, National Company Law Tribunal, Appellate Tribunal, Supreme Court of India. When it comes to competition, it is Competition Commission of India, then appellate body is National Company Law Appellate Tribunal, then Supreme Court of India. So likewise, there are specialized quasi-judicial forums which we are calling out tribunals to help these corporates to easily and speedily adjudicate on these matters. So these matters will not normally fall under the jurisdiction of the normal courts, which we are saying. The normal courts means like sub-courts or other courts. So these laws under this supervision of this tribunal will be able to resolve the issues as fast and swiftly as possible. So I think your question was regarding that, and so my answer is that these are basically, you can call it as tribunals.
Yeah, that's clear. So now, what are the major reasons for disputes in relation with the governance of a company?
Your question is specifically regarding the governance of a company and the disputes arising out of that company. So mainly, if you ask me about the reasons for the disputes in the company, I will say that it's a lack of transparency or lack of disclosures or lack of proper documentations are the reasons for the corporate disputes. So if the company is giving more importance to bring this transparency, to bring more disclosures, automatically the level of disputes will be lesser in those companies.
Okay. So in your opinion, what are the different ways one can avoid dispute between the management and the shareholders?
I have answered that question partially in your previous question. So when I told you that like bringing more transparency or bringing more disclosures onto the table will help the companies to resolve the disputes to a greater extent. For that, conducting the meetings, proper meetings such as board meetings, committee meetings, shareholders meetings in a timely and most efficient manner will instill confidence in the mind of the investors, stakeholders, government and general public. So by doing that, a company can easily avoid any kind of situations that are leading to disputes.
Okay. So my next question is whether a civil courts have the jurisdiction to adjudicate upon the corporate matters?
Okay. So, if you the question is regarding the civil courts, whether the companies can approach civil courts, right?
Yeah.
I had earlier mentioned that when it comes to many of these matters connected with the corporates, there are specific tribunals to handle those matters. So normally, civil courts does not have direct jurisdiction to entertain any of the matters relating to the corporate at the primary level. Of course, in the appeal stages, there are jurisdiction for the high courts as well as supreme courts in several matters. For example, if you comes to a dispute regarding the Companies Act specifically exclude the jurisdiction of the civil courts with respect to all matters covered under the Companies Act. The appellate forum for that is National Company Law Appellate Tribunal. That is also a specialized forum. And above that, if you want to go for an appeal and you are aggrieved against order of the NCLAT, you have to approach the Supreme Court of India. So that we cannot say that the civil courts does not have the jurisdiction. The primary courts does not have the jurisdiction. The specialized courts will be dealing with that. And finally, apex court have the authority to deal with all these matters.
Okay. So my next question is, whether the commercial courts and the National Company Law Tribunal have the same and similar function?
Yeah, it's a good question actually. We know that National Company Law Tribunals are basically dealing with the disputes relating to mainly to two acts. One is that Insolvency and Bankruptcy Court, where NCLT is the adjudicating authority, NCLAT is the appellate authority. Similarly, when it comes to Companies Act also, any governance related issues such as corporate disputes are being handled by the NCLT as well as NCLAT. So these four acts are actually covered under the scope of NCLAT, but NCLT also. But when it comes to commercial dispute, it is predominantly under the Commercial Courts Act 2015, where any disputes arising out of a gamut of laws which are covered under the Commercial Disputes Act. Example, if you say admiralty and maritime laws, any disputes relating to an agreement like franchising agreement, shareholders agreement, investors agreement, share subscription agreement, or any matters connected with the maritime laws, admiralty laws. And then comes to any immovable property which is put into use directly into a trade or commerce. All these matters are now before a specialized court called as commercial courts. So these two, if you see the coverage or scope of these two acts, I would like to state that commercial courts having the more wider scope than the other forum like NCLT.
So that is very insightful. Now my next question is, can a shareholder approach the commercial court for a matter concerning oppression and mismanagement?
See, a matter which is covered under the Companies Act and oppression and mismanagement is an exclusive jurisdiction of the tribunal. Normally, a person who is actually having aggrieved by actions of the management cannot approach any other forums because Companies Act itself excludes the jurisdiction of other courts. But if suppose there is a shareholders agreement in the company, and there is a dispute arising out of that agreement, then the proper forum to adjudicate that complaint is not the Companies Act or the NCLT, because it is covered under the scope and ambit of the Commercial Courts Act. So if a dispute arising out of a shareholders agreement, the person may have to go under the Commercial Courts Act. And in another scenario, if this particular shareholders agreement contains a clause for arbitration to resolve the disputes, then neither the NCLT nor the commercial court will be dealing with the disputes. It will be dealt by the arbitrator who is appointed under the agreement. So your question is whether they have the jurisdiction. Depends upon the situation. It will change.
Okay.
Normally they don't have.
Okay. So my next query is, so now the powers of the tribunal. So what are the powers of the tribunal to adjudicate on the matters that is covered under the oppression and mismanagement?
See, oppression and mismanagement is a very wider topic which needs an elaborate discussion. But when your question was specific to the powers of the tribunal, tribunal is having ample and more powers to resolve any dispute, to bring an end to the matters complained of on just and equitable ground. Okay, so the terminology that to bring an end to the matters complained of is giving the ample and more powers to the hands of the tribunal to resolve a dispute in front of it. And the only thing is that to bring a just and equitable grounds.
Okay.
So tribunal, as defined under section 242 of the Companies Act, is very powerful like a normal court, and they can bring in justice onto the table and resolve any matter which is in front of it. Okay.
Okay. So that was clear. Now my next query is whether the parties, if they can directly approach the High Court under Article 226 of the Constitution for the matters covered within the ambit of the tribunals.
See, Article 226 of the Constitution of India is empowering the High Courts to deal with any matters, which is actually even writs or any other matters. But when it comes to tribunals, the High Courts had, though it is within its power, had conferred that power to the tribunal through the special laws, and the tribunals have the power to adjudicate on those matters, including the interpretation and implementation of the statutory laws. So due to this particular conferring of the rights, tribunals are the right forum to adjudicate that matters. Normally, High Courts will not interfere into it, but High Court is having a supervisory jurisdiction under Section 226 as well as 227 over this tribunal and its orders. So when this tribunals is actually not exercising the powers conferred or exercising the excess jurisdiction, the High Courts within its jurisdiction can always look into this matter and see that whether everything is well with this tribunal or not. So directly your answer, I would like to say it's a no, but indirectly or through implication, the High Courts can look into these matters.
Okay. So thank you, sir, for the wonderful information that you have shared. So let's wait for more information in the coming videos. So thank you for watching.